Hi everyone, welcome back to our channels. My name is Bong and today I'm here with Kun Nop. สวัสดีครับ
สวัสดีค่ะ
So today we still talking on the developments of personal data protection law in Thailand, especially on the issues of the criteria and policies of the protections of personal data that's sent or transferred to overseas. And before we go to further details, I would like to give you the overview of these sessions. So today's session will cover three main parts. So the first part will talk about the adequacies of personal data protection standards. And second, we will talk about the data protection policy within the group companies. And third, we will talk about the appropriate protection measures. And before we go through each topic, I would like to give you an overview of the definitions of the sending or transferring personal data to overseas, which is stated in the draft subordinate regulations. The sending or transferring personal data means sending or transferring the personal data to the data importers who is not belong to the same organizations of the data exporters, which include remote access from the overseas and the use of cloud service providers. And this definition is not cover the transit of personal data, which means that there is no access or interference of the personal data. So, Pinop, do you like to add any information to these definitions?
Yes, I think the point that you have mentioned about transit is quite critical because by the nature of it, right, whether or not the data is transferred to or outside or actually rests in another server outside of Thailand, but intention is not to transfer or to disclose the data to another operators or another businesses. And another thing that I want to also point out is that actually because PDPA has extraterritorial effect, and for overseas data controller, they can also be subject to the requirement under the PDPA level as well. So when the businesses outside of Thailand collects personal data directly from data subject in Thailand without any bypassing or without any involvement of data controller here in Thailand, it does not consider as a transfer from one data controller to another data controller who is actually an overseas data controller, and that should not constitute the cross-border transfer under the definitions of the PDPA, and then the requirement under the cross-border transfer section 28 and 29 should not be covered.
So let's move to the first topic. So the first topic will talk about the adequacy of personal data protection standards. So normally, sending or transferring personal data to overseas is prohibited unless the destination countries or international organizations has adequate on the personal data protection standards. And these subordinated regulations has laid out the minimum requirements or have set certain factors that we need to take into considerations. So Pinap, could you please provide us in more details on that factors?
Sure. Let's go back one step. Actually, the requirement is quite similar to, again, the GDPR, whereas we actually adopt the requirements on the cross-border transfer, right? So the concept is that if the transfer is made to a third country that have the same level or adequate level of protection of personal data, that should be okay. So we normally call it like whitelisted country, and the list to be announced by the PDPC. Which the factor to list out all those whitelisted country, there are three main criteria or factors. So first thing first is to understand whether or not the destination country actually has the law about protections of personal data. So if that country has, then it ticks one of the requirements. And second is whether or not that third country has a regulator that's efficiency or assistance that's going to enforce the requirements under the law of personal data protection in that country. And thirdly, of course, if there is any like international commitments that Thailand has with other country about, for example, data transfer or free flow of data within the region. So those are the three main factors that the PDPC will look into when coming up with a list of whitelisted country. Thank you.
So let's move to the second issue. It is about the binding corporate rule or the BCRs. So this is in the case that the sending or transferring of personal data is transferred within the same affiliate or group companies. However, the BCRs must be examined and approved by the PDPCs. So the draft subordinate regulations also provide the minimum details that must be used in the BCR. So Pinot, could you please tell us about the detail that need to be inserted in the BCR?
Okay, so again, one step back, the BCR is like the internal policy between the group of corporations around the globe actually. So the concept of BCR is that if you have the BCR that has been, as you mentioned, approved by the PDPC, then you'll be having a blanket exemptions for the whole group to transfer data outside of the country and between each other. So the concept of BCR is actually something that's quite similar to the GDPR. So the minimum information that has to be put in is like, for example, you need to have the corporate structures and the contact details, and then you have to talk about the details on how to transfer the data within the group. And of course, the key fundamental issue is the binding nature of it. The BCR has to have binding effects amongst the group of company entities within it. And another thing is about the liability. So there should be a set of requirements on the liability of the businesses who transfer the data within or to the operator outside of the country. And then the exemptions that should not be fall within the liability is only if that entity or if the exporter do not take part of any of the activity that's caused any damage to the transfer or to the data subject. So that is the key concept with BCR. And the businesses that need to already comply with the GDPR, you might already have BCR that your country within GDPR country has agreed upon. So I think what we would want to recommend is that you might want to use that BCR that might perhaps been approved by ICO or any other GDPR regulator, and then adopt that to be used as the first draft for Thailand, and then perhaps localize it to make it a little bit compliance with Thai law, maybe having like a country addendum or something like that along the line, and then send it for the approval from the PDPC so that you can enjoy and have what is called a blanket approval or blanket exemptions for the transfer, again, within the group of corporation, not to anyone else.
Okay, cut. So the last topic is about the appropriate protection measures. This exemption will apply only when there is no adequacies on the protection of personal data of the destination countries or international organizations, and there is no BCRs. However, these appropriate protection measures must be complied with the minimum standard set out by the PDPCs. However, this appropriate protection measure is not required to be reviewed or approved by the PDPCs. So Pinap, could you tell us a bit about the details of the minimum standard that need to be put in the...
Yes. Actually, essentially what you have said is correct. I think one of the key advantage of this appropriate safeguards is you don't need to get it approved by the PDPC, you don't have to wait for it. It's just that in a nutshell, you need to have an agreement or what we normally call a standard clause that you have entered into with the data between the data exporter and the data importer. So the concept is that there will be two types of the standard agreement. One is C2C, which is controller to controller, and another set of minimum standard clause for agreement between controller to processor. And actually the PDPC come up with a list of what they want to see, and then we have added on this clip as well. So these are the list of minimum requirements that you need to put in when it comes to C2C agreement or when it comes to C2P agreement. But the fundamental things that we have to consider is that this agreement need to enable the ability to enforce the right of the data subjects against the importer outside of the Thailand. And again, I think it's the same thing as when we were recommended about BCR. So if you have the affiliated that already have the standard clause or the template of C2C or C2P agreement, then it's better to kind of like adopt that template and make it a little bit localized to comply with the PDPA and the minimum standard list that is expected from the regulator, and that would be good to go.
Yes. So this is all for today's. So thank you for your attention, and please stay tuned for the next video clip. So thank you and goodbye.
Thank you.